Well, it looks like signs like these are signs of the times. Every neighborhood, it seems, that you go to has a foreclosure. Well, we just met up with an attorney who's got a way to stop foreclosure. As a matter of fact, even if your house has already been foreclosed, he's got a way to deal with it. This is something you're not going to want to miss. Hey, I'm here at the office of Glenn Faza, attorney. How are you?
Good to see you. Thanks for coming by.
And we're going to talk today about mortgages and loans and all these crazy things with foreclosures and all that stuff. So let's get started.
Okay, after you.
So there are a lot of people that are in trouble with their mortgages, right? I mean, we've been hearing about the mortgage meltdown and the real estate values have dropped and all kinds of crazy things have gone on. And you found a way to help people that are in trouble as far as maybe in foreclosure or late on their payments and so forth. But before we talk about that, I want to get back to some of the history of how things used to work, or at least how they were supposed to work, and then where we are today with all this stuff. So, so let's look at, I'm going to buy a house, I go to a bank, I'm going to get the mortgage there. What used to happen?
What used to happen is that you deal with the bank you get your loan from, you deal with them all the way through the process. So if you take out a traditional 30-year mortgage, that the bank grants you the loan to buy the house. They hold the note, which is the right for them to collect payments, and they're the ones that also record the mortgage, which is the security interest, allowing them to use your house as collateral if you default. And typically throughout the whole time, if you had the mortgage for 30 years, the bank would be you deal with the same bank, or perhaps they had a servicing wing that you would deal with to collect payments. But you knew that the bank you took your loan out with, typically you're dealing with them all the way through the process, or at least maybe until you refinance or sell the home. Right.
So I'd go to the bank right on Main Street, and I'd sit with Mr. Banker, and we'd go through the process. We'd do an application. They would check my credit. They'd make sure I actually had a job and I actually had credit and I had some ability to pay. And then ultimately they would issue the loan. Now in Massachusetts, at least, if not all other places, we'd have a mortgage note, and then we'd have, what's the other document?
The mortgage is the security instrument. Okay. It's the security for the loan. Okay. So the bank is giving you, could give you hundreds of thousands of dollars to buy the house. They want some collateral for giving you the loan, and the mortgage, which is the security instrument, basically attaches the house as collateral to the loan. So if you default, there's certain provisions in the mortgage contract that allow them to accept what they call accelerate the note, making all the entire amount due immediately. And then if you don't cure that default within a period of time, then they can go ahead and invoke what's called the power of sale. They conduct an auction, sell the home, and usually they typically buy the home back themselves, and then either resell it or assign their winning bid at the auction.
Gotcha. So I got the loan, I bought the house, and now I'm supposed to pay. And if I don't pay, they have the Main Street Bank, that banker that I talked with has the legal ability to say, hey, pay this loan up or we're taking the house.
That's right, and it's a contract. It's a valid contract, so you do have the obligation to make your payments, and they do have the rights to go ahead and accelerate and foreclose on a typical transaction where it stays in the same hands of one bank or lender, or well, like you said, that's the way it typically worked, and how traditionally people would think that their mortgage is being handled. Right.
Now, in some states, when we get to that foreclosure process, they actually have to go to court. But in Massachusetts, it's not quite that way, right?
That's right. This state's called a non-judicial foreclosure state, where they don't need permission from the court to foreclose. They have the right in the mortgage itself, where it says statutory power of sale. There's a law that under certain conditions they're allowed to invoke this law, and as long as they follow the requirements of the law, making the publication in the paper, sending the notice to the homeowner, so forth, they can go forward and conduct a foreclosure without court permission. The only time they have to get anything from the court is at the beginning of the process, where they just have to tell the court that you're not in the military, so you have certain rights under the Civil Service Member Relief Act.
That's where we used to see those little ads for a Soldiers and Sailors Act or something,
exactly.
Right? Okay.
But you know what's interesting is that That's almost like a rubber stamp process. Unless you're in the military or you just got out, you're not entitled to any relief under that act.
Okay.
But the homeowner gets that, and this is interesting because I talked to one of my clients. When you get that in the mail, it has a land court docket. It looks like, and it does reference that the bank filed a complaint to foreclose, which is what it is called, a complaint to foreclose, but it's just for the purposes of this rubber stamp hearing. But it makes the homeowner think that the court is going through a process by which they're signing off on the bank's rights on the merits of their the legality to foreclose.
Right.
And homeowners, they don't know that either. So it's almost deceptive, that process in its own right, because the court is making no judgment on whether the bank has any right at all to foreclose, just that you're not in the military.
Okay, so if I stop making the payments, then I'm going to get a letter that says, basically, are you in the military or not, right?
Well, they'll probably send you a notice of default.
Okay.
And then they'll give you some options in there. The master law gives you 150 days now to cure that default.
Okay.
Then if you haven't cured it, they'll record the notice of the civil service member hearing and that they filed a complaint to foreclose, and they'll send you a copy. Usually you have about a month to file an answer to that and to show up at a hearing. But like I said, if you're not in the military, if you're not entitled to rights, most people will never contest that. So it just goes through, and then the court stamps it, allowing the bank to continue.
All right. So if somebody's not in the military, that process really doesn't apply. So then the next step would be that the bank would actually take steps to take the home away.
Right.
And now in Massachusetts, as you said, there's no court process. So once that first letter, the military thing goes through, the next thing you could actually know about is seeing an auctioneer on your front lawn.
Well, they're supposed to send you these notices, certified mail, the notice of the auction. And like I said, they're supposed to publish it. The law says that they have to publish it in a local paper 3 consecutive weeks before the auction. But then after that's done, they'll show up, with an auctioneer, a couple of witnesses, and it could be a quick process where you don't even know that it's going on. Because, like I said, typically nobody's going to show up at the auction besides bank representatives, allowing them to foreclose, buy the home back right then, and then they just move on, and they'll end up, recording a foreclosure deed, attesting that they foreclosed, and now they own the property.
Wow. Okay, so the whole process, it sounds like, a homeowner could sort of not realize exactly what's going on, and it also sounds like I hear you saying the bank is supposed to do all these things. So tell me about how this situation evolved where banks are really doing things they're not supposed to be doing.
Well, in terms of going through the actual foreclosure process, they typically, that's not where the violations are, because once they're sending you the notice of the hearing and then they publish it, those things are usually done accurate. It's backing up a step and actually looking to see, does that bank who's publishing this notice saying that they hold your mortgage, does that bank that filed the complaint to foreclose saying that they hold the mortgage, which gives them the power, do they have standing? And that's the key. That's what we're saying here for homeowners. We're not saying that you don't owe the money, because you do owe it to somebody.
Right.
We're just telling the entity that's foreclosing, do you have standing to foreclose? Prove you have standing. And in any court action, and anytime you're trying to assert rights to anything, the first threshold issue is standing. Prove that you have the right to assert certain rights and to go forward with certain activities. And that's what we're doing by building a case for homeowners and actually filing actions with the court, affirmative on behalf of the homeowner, to force the bank to prove that they hold the note, they hold the power of sale, and that they can connect all the dots and have all their paperwork in order. Okay,
so we've been talking so far about me going to Main Street Bank and meeting with the banker right across the desk from me. But in, 1999, 2000 or so, that process changed a bit, and some of the bigger banks were doing things differently. What was that about?
They created basically a system, and they created an electronic recording system, first of all, which is called MERS, M-E-R-S, Mortgage Electronic Registration System. A lot of the executives from some of the big banks created this, which is outside the public recording system, so that they could quickly transfer loans between banks in order to quickly foreclose on people.
Because in Massachusetts, we have a county system, right, where each county has a registry of deeds, and that's where these documents are supposed to be copied.
And that's where all property rights should be documented for the whole world to know who owns a property, who has a right in property. You'll find half of mortgages are probably in this MERS electronic system. So if you look at the registry of deeds, you'll see MERS, MERS, MERS on half of mortgages. You might say, well, what is this MERS here? It's just in the mortgage contract, they're named as a nominee for the lender, basically, which is just a placeholder. Should be. But what they've been doing is they've been sometimes foreclosing in their own. It's a recording system, and they've been asserting rights. They've been assigning mortgages. They've been doing a lot of things that they have no business doing, and that's what's causing a lot of problems for banks in order to get their paperwork in order.
All right,
that's part of it.
Let me see if I get this. In Massachusetts, the banks were supposed to be going to the registry of deeds with all these documents, but instead they cooked up this MERS thing, which was sort of their own plan to do this stuff. But that process is not a legal process in Massachusetts. So what do I care as a homeowner? I'm having trouble making the payments. So what do I care where they recorded this stuff?
Right, and I'm sure a lot of homeowners have seen a lot of recent talks in the news with settlements from the Attorney General, right. and one of them recently was with a lot of the major banks. MERS is involved in that lawsuit. Some of the counts against MERS are still pending, but they're being attacked for a lot of these things by attorney generals, by some of these registry of deeds, the recorders, the registers,
because they haven't been paying the fees all this time,
right? That's their main complaint, is that there's millions of dollars owed to the public.
So they get millions from the federal government, or billions, I should say, and then they're beating out Massachusetts of fees that they should have been paying.
Exactly, but I think more importantly is the point of public records. When you're talking about a home and you're talking about the fundamental, the basics. The foundation, rather, of the family and so forth. It's such a major purchase, such a serious transaction. The recording system is set up for the whole world to see who holds any ownership right in your home. And when you see this, the MERS is this placeholder, so that outside of the system, the banks could quickly, sell this, assign the mortgage and sell it and so forth without anybody knowing. Until the time came when they'd foreclose, and then a bank who you had no idea who they are, would show up and try to foreclose or at least start the process. When you're thinking, hey, I took a loan out with my community bank or whatever bank it is, and it's, some new entities are showing up, and you have no idea who they are, and they don't really have to prove it unless you assert your rights and make them prove that they properly acquired these rights to move forward and to displace you. And this is very serious, because you're displacing a family, and you're causing some turmoil and trauma to family for the rest of their lives. So I'd hope that anybody would make sure that they had the legal right to do these things before taking such a drastic action. But the fact is the banks were doing all of these things, the robo-signing, everything, and they didn't care. They just were trying to generate more money for themselves.
So for the typical homeowner who's in a position where, maybe somebody was sick or lost their job, whatever, they've fallen behind in the payments, they've gotten these letters from the bank, they're getting, certified letters, whatever. If I'm hearing you right, you're saying that in many cases, the bank has no right to actually foreclose with them.
It depends on the situation, but very many times, the bank will not be able to, the bank that's trying to come after them will not be able to prove what is necessary to take these steps to foreclose, because of this whole electronic recording system, because of the whole system where they created these mortgage-backed securities to generate billions of dollars for the banks that then got bailed out again. Because they created the system in their haste to do these things, it's made it very difficult for them to get the paperwork in order. And so that often is what we're finding, whether it's that type of situation, or if from the time you took out your loan, if we find other evidence of predatory lending that goes to the basic level of when you dealt with a mortgage broker who didn't verify your income, who didn't do the diligence to see, can you actually repay this loan? Yeah, it's everybody's dream in America to own a home. So it's easy for people when they're enticed by a program where they don't have to put any money down or even prove their income to jump at that.
Right.
But when you're dealing with a huge bank that's creating a system to take advantage of people, homeowners have rights, and this is we're pursuing this. We're using a lot of this consumer protection law, which is in Chapter 93A, which is a very common statute that gives the small homeowner against the big bank some very powerful ability to outline unfair and deceptive business practices. And if the bank doesn't give you a proper offer or make some type of accommodation, if we have a good case against them and we have to litigate it, they're up for potential double, treble damages and a lot of punitive penalties. And that's the basis of building a case, and that's the reason why you need to get the leverage.
So it sounds like what you've done is a lot of research, I'm guessing, to come up with this. But what you've done is you've sort of turned the tables here, where Megabank has been taking advantage of people in many ways, have been taking federal money, been depriving the state of their fees.
That's right.
And when the homeowner who's in trouble goes to them and asks for help, they're basically brushing them off. Now, you've figured out a way to sort of turn that around and say, hey, we've got rights as well. How does that work?
Yeah, what we'll do is we'll sit down with anybody, regardless of what stage they're at in the process, whether they're even possibly current with their loan, but they're just finding that the payments are just unwieldy. They're just too much. It's such a burden that they're draining all their finances just to make the payment. Or if they've even already been foreclosed on already, whether in either situation or foreclosure is imminent. We'll sit down and take a look at, like I said, their whole situation from the time they took out the loan. We'll do an analysis, kind of an audit of their mortgage closing documents to see if there's any violation of federal, state law. That's where we begin the building of the case. We'll do a title examination to see what's been actually recorded on the public record, to see who's asserting a right currently to your home, who's asserting in any type of interest to your home, and which you're trying to defend right now from foreclosure. And in conjunction with the document audit, the title search, we try to see if it was securitized. Sometimes we need third-party audits and so forth to find these violations, because they're very complex and in a lot of public filings from the SEC, and you got to dig into thousands of pages of documents. But if you find these things, there's a lot of indicators that we can see on first examination to see if it's a good candidate. But if it meets our criteria, we'll sit down and plan a strategy for not setting up the bank, but building the case against them, where we know that if we have to file suit and litigate, we're going to have a very good chance of prevailing on those things.
Now, it seems to me that there are three groups of people that are maybe in trouble with mortgage-wise. If there's a group of people who are having a really difficult time just making the payments, and they may not be doing anything else with their money but just making those payments.
Exactly.
And those are the people that are asking the bank for a modification. In other words, they want to just sort of change the terms a little to make it easier.
Typically, yeah.
What is the bank's incentive for doing that? In other words, you've established that there's been a contract already. Mm-hmm. We've both agreed, me and the bank have agreed we're going to make these payments and these amounts and so forth. What's their incentive to change that?
Well, based on your situation, basically the alternative from them to work with you is to foreclose and take the home, which costs them a considerable amount of money to go forward with it. But they'll have attorney fees, or if they take the home and buy it back, they'll have to hire real estate agents to sell it, the maintenance fees. Banks don't want to be in the business of holding properties. So what you typically show them is, here's where you're going to be financially if you foreclose on the homeowner. If you work something out with them, you're still going to be in a better position. And here's the part of the fraud or the scam is that you're presenting this to the bank, who you believe owns, is the true party of interest here, when typically they're just the servicer. They don't own the note. They don't have any real interest in your home, so they're not really incented to really work with you.
Right.
If they were the real owner of the loan, who had to deal with a real situation that the homeowner might default and get foreclosed on, they would most likely do something that's in not only your best interest, but their best interest, because they're the one holding the asset. They're the owner. So you're dealing with a servicer. A lot of times, and this is counterintuitive, is that they get paid, they're incented to give you the runaround, to have you drum up more default fees, to foreclose on you. This is how they get paid a lot of times, which is contrary to your interest, but also the owner of the loan itself.
So the servicer, this is the bank or the company that's actually accepting the payments and sending the bills?
They merely collect the payments on behalf of the owner of the loan, which a lot of times, like I said, in the complex process, might be some type of trust that has thousands of loans, and they're remitting the payments and so forth. So they collect it, they service it, that's it. They have no ownership typically. Now, it's not in every case, but if they can come forward and prove that they have ownership and that they hold the mortgage, well, then maybe they can actually foreclose in certain circumstances. But typically, that's not the case on these loans that, in this large period of time.
So that makes sense that if you've got a servicer whose job it is to just bill me and collect the payments and collect those late fees, then they don't care if this goes on forever. They're making their money no matter what. So they don't want to deal with me, right? Now, then you've got the people that are in the middle of the process that are in the process of being foreclosed. So again, you're saying that you're going to do an audit. You're basically going to look at all the paperwork and make sure that it's correct to show whether or not these folks really have the right to do that foreclosure.
Right. Sometimes, and what you're just describing, somebody might be actually really in imminent danger of foreclosure. The auction might be within a week or so. So sometimes you have to take some quicker steps, and we might have to file some type of motion in the court for an injunction or so forth to buy us some time to do these things. Sometimes even somebody might have to file a bankruptcy under certain circumstances to give you time to prove these things. It's not advised, but the goal is for us is to buy as much time as possible in order to build the case and to get the relief we want. And here's the interesting thing. The third class of people we're going to discuss is people that have already been foreclosed, actually. And that's the interesting thing. If the bank, in my position, it doesn't really matter if the bank forecloses. It matters, obviously, if they evict you and so forth. But even up to that point, at an eviction hearing, you can raise the issue of standing. And there are cases that have come down this way where you can still, even after they foreclose and there's an eviction hearing, summary process, you can raise the issue of standing. Did the bank have standing? Did they have these things? If not, then the foreclosure that they did was invalid, so they have no right to evict you. And that's one of these major cases that's actually under review with the highest court, Eden versus Fannie Mae. It was done at an eviction hearing, and it came down on the side of the homeowner. Because from our perspective, if the bank that forecloses didn't have the right to do so, well, it's an invalid foreclosure. They didn't obtain any right to your property. So if it's a nullity, it's a void foreclosure. So if they resold it, they sold nothing. They can only sell whatever interest they acquired.
Okay.
So even if they sold it to another innocent homeowner, if the foreclosure was done invalidly, it's our position that the bank doesn't hold any interest to your home and they convey no interest. So even if you've been foreclosed on, there still are potential remedies for us to go against the bank for these unfair practices.
So you've got people in various stages of this that really should be looking at these details. I mean, if they're having trouble, then they should be looking at it now. If they're in the process of foreclosure, you may be able to do something about that immediately. But that's interesting that if it's already been foreclosed, then there still may be some recourse.
Right, and those are the people that have, they're long gone. They've long given up on the property. It could be several years, and they don't think there's anything that they can do.
Wow.
So to give them an opportunity, let's take a look at it. Let's see who foreclosed on you. Where did they get the right from? What happened here with the note and the mortgage? If they didn't have their ducks in a row, and like I said, there's past couple of years have been some very important cases coming down in the state to confirm this. Then that's an invalid foreclosure, and you might have some remedies there.
Now, if you were to look at all the mortgages in Massachusetts at this time, what percentage would be in this situation where things are messed up enough that you have some recourse? It's
difficult to say. I would say between those years, if anybody has an existing mortgage between 2000 and 2008, if you see MERS involved on the public registry or in any of your documents, if it was any of the major 5 banks, a Bank of America, J.P. Morgan, Chase, so forth, Wells, if they were involved, there's a very good likelihood that was securitized, that these processes will work here, and we'll be able to find some way to build some leverage. I don't know percentage, but oftentimes they said upwards of 80% of mortgages between those years were securitized. And if currently half of America's mortgages are on this MERS system, this electronic recording system, that's quite a few. And so, like I was saying, regardless of what stage you're in, if you're even current but you feel the mortgage is oppressive, or if you've been already foreclosed and long gone, let's sit down and take a look. We do a free analysis because we're trying to educate people basically as to what your potential rights are. and let's see if it meets any of the criteria, or we can move forward and try to get you something that is significant now, or even if you've been to foreclose, try to get you some either monetary or other damages.
You just said something that right away catches my attention, and that is the free part. I'm assuming that somebody who's late on their mortgage or in the process of being foreclosed or has been foreclosed, they've not got a lot of cash sitting around to come in and spend on attorney's fees and so forth. So how does that work? They're going to be able to sit down and at least you can discuss with them?
Absolutely, because we wouldn't want to move forward if it didn't have a really good path to success. We'd want to make sure that there's at least some criteria that we on an initial review that have a good meet our strategy points and so forth. We're working with a lot of people on a very fair basis. We're not trying to take huge fees and so forth. We're trying to work out payment plans with homeowners. A lot of people, if they were foreclosed and evicted, they would have to find an apartment to rent and so forth. So that's going to cost them money. If we have a way to keep them in their home, then they don't have to spend money on finding elsewhere to live and so forth because they're not displaced. But every case is different. We're trying to work with as many people on as fair a basis as possible. And first and foremost, trying to educate people to know, look, you do have rights here. Stand up and assert them. Otherwise, the bank will steamroll through you without having to get any authority. And then they'll move forward to the next victim. Wow.
Somebody who's in this situation, listening to you saying, hey, maybe I've got this kind of problem. Maybe there's a way that I can do something. Who should they go see? Is it just any local attorney, or is there anybody specializing in this sort of thing, or who knows about this?
There are some attorneys doing some of these things. A lot of these concepts and a lot of these cases came down the past couple of years. So you'll hear advertisements for loan modification, which have been going on for many years. And we've known a lot of people that have gotten scammed by the typical loan modification process, paying fees up front and not getting any work done. And as we know, the typical process doesn't really work that well anyways, even if you're dealing with somebody who knows how to work it. So people, they'll get inundated by, once they've defaulted, it's a matter of public record, they'll get inundated by companies, by sometimes attorneys, but sometimes just companies, from across the country, from California, trying to get them to work with them. And unfortunately, we've had a lot of clients come in who've gotten scammed by these companies that, like I said, are across the country, aren't attorneys, are getting them to pay money up front. And I'd advise people to, regardless of who you work with somebody, work with an attorney who's local, that you can come and sit down with, who you can hold accountable for their work and is actually regulated by the state agency, the Board of Bar Overseers, for their conduct and have to abide by ethics and so forth. Make sure they're local. Don't work with an out-of-state company. It's very difficult to get your money back at that point.
Well, and that's because once somebody becomes late on their payments, that their companies actually sell that information. You can buy a list of people that are late. So when you get a letter in the mail, even if it might look official, you'd have no idea whether that person is legitimate or not.
It's difficult. And a lot of times these companies will make their letters look like they're official government documents so that you open them. But they'll have a variety of programs, and some of them might be legitimate, some won't. Like I said, it's hard to tell, but I would just suggest that if it's an out-of-state company, well, you can't come and sit down with somebody and talk to them face-to-face for free analysis to judge if they appear credible, to talk to them about the process. I would suggest you not, fork over thousands of dollars before that happens, because not only will you lose that money, but all during this time when they're supposedly working on your behalf, you're racking up more late fees. You're hurting your credit more, and then you might be foreclosed on. I had somebody worked with a California company. They did nothing for her for 2 years, and then they called her up one day, and the day before the auction, told her, you better go find a bankruptcy attorney. And they did nothing for her, and she was basically hyperventilating in our office here. And it's a shame. We've had several people getting scammed by Florida companies, California companies. Work with somebody local. This is something my office, my team of people, attorneys and staff and mortgage professionals that work with us, have developed over several months a process. We're not the only ones doing this, but we do a very comprehensive analysis to build the best case on behalf of the homeowner, to get the leverage, to get them some actual relief.